United States of America upheld the individual autonomy of the patient by ruling that the state would need to provide clear and convincing evidence of the individual's wish to end life assistance in order to persuade the doctor to do so. Furthermore, Justice Misra and Judge Pushin have quoted the decision in Vaco Vertis, Quill, 1997, in which the Supreme Court supported the state of New York's ban on physician-assisted suicide. The court made a distinction between physician-aided suicide and letting a patient reject life-supporting treatment. The court opined that the declining treatment was legal as a component of the legal system, which provides the right to bodily integrity and individual autonomy. In a similar context, Judges Chandrachud and Bhushan discussed Cardozo's opposing opinions in Schlondorf v. New York Hospital Trust, 1914. The case was decided by the New York Court of Appeals. The Supreme Court of India referred to this case in order to ensure that personal sovereignty serves to protect the right of a person to initiate the withdrawal of life-sustaining treatment in cases of a fatal disease. The court referred to numerous jurisdictions for extensive research regarding jurisprudence. Some of these nations are Singapore, Canada, Switzerland, Australia, Belgium. Netherlands Justice Misra even quoted the judgment in the case of Carter Vors, Canada, 2015, where the Apex Court of Canada stated, "Physician-assisted suicide shall be permitted in certain situations where the medical state of an individual is critical and irrecoverable. However, such consent should be provided by an adult in clear terms." He has also spoken about the protections put in place by the Parliamentary Joint Committee, which was established in 2016 with the aim of establishing both substantive as well as procedural safeguards. In order to implement advanced medical directives in India, he also took inspiration from the committee and developed measures. Additionally, he has studied the situation in Australia, where the right to refuse medical treatment and advance medical directives have both been recognized as a part of common law, and where the individual's best interest is the guiding principle for deciding whether to discontinue treatment or not. For instance, the High Court of Australia determined in Secretary, Department of Health and Community Services Virai, Shibasi and SMB, 1992, that an individual, major of sound mind, can take voluntary decisions regarding what should be done to his or her body. Also, his decision is protected by common law. Moreover, the court referred to the following cases: Pretty v. the United Kingdom, 2002, Haas v. Switzerland, 2011, Lambert v. France, 2015. In these judgments, the court noted that states had authority in end-of-life circumstances, maintaining a balance between both the principles of autonomy and the right to life, and allowing termination of treatment, if adequate precautions are put in place. Allowing passive euthanasia in such circumstances would not be against the duty of the state under the convention. In addition, the court has mentioned the prerequisites for consulting other doctors, the precondition that the person has the legal ability, the person's medical condition and level of pain, the existence of alternative solutions, etc., that are outlined by laws in the Netherlands, Luxembourg, and Belgium concerning the consent of the person. Euthanasia is only permitted in certain countries when all other treatments have failed and the person's pain is intolerable and cannot be relieved in any other way than death. These prerequisites have been very carefully outlined in these laws. Additionally, Judge Bhushan discussed the situation in Singapore, where the Advanced Medical Directive Act, 1994, contains comprehensive provisions concerning the same, and in Switzerland, where Articles 362 and 365 of the Swiss Civil Code, 1907, provide for the performance and enforcement of advanced medical directives. Analysis of the procedure and guidelines laid down by the court regarding the authorization of an attorney and the issuing of advanced medical directives. The right to die with dignity, which is found in Article 21, has been rooted by Justice Misra in light of the aforementioned international jurisprudence. He has established various protections and processes with regard to the advanced medical directives and attorney authorizations, which have been approved and reinforced by other judges on the bench. He views this as a question of interpretation of the Constitution, which the court is obligated to do. The regulations provide that only an individual above the age of 18 years, of sound mind, who is capable of communicating, reacting, and comprehending the repercussions of signing the document, and who has full information and understanding, may freely sign it. The declaration must indicate informed permission and clearly and indisputably specify when medical care may be